Let's fill out the Illinois General Power of Attorney together, the document that lets someone you trust handle your money and property. Start with you, the principal. Type your full legal name and where you live. Use your full legal name exactly as it appears on your ID, so there's no doubt who signed. Now name your agent, the person you're giving authority to. Here, Ben Carter, with their address. And name an alternate. Here, Carlos Diaz, in case your first choice can't serve, so your document doesn't stall if something happens. Now the powers. The form lists subjects A through N. To give your agent authority over everything, initial the line in front of N. To grant only some, initial just those specific lines instead. Then choose when it takes effect. Here, effective immediately. One important thing. Depending on your state, a general power of attorney may stop working if you become incapacitated. If you wanted to keep working no matter what, ask about a durable power of attorney instead. Finally, print your name and date it. A general power of attorney usually must be signed in front of a notary, and some states also want witnesses, so don't sign it alone at the kitchen table. Then, give a copy to your agent and to anyone they'll deal with, like your bank. First things first, the document needs to be executed by the principal. That's the person granting the power. So the principal must sign the document. That's your starting point. Next up, you'll need one witness present, just one, but make sure you have that covered. Now, here's an important one. The principal needs to acknowledge his or her signature before a notary public. So you'll want to arrange for a notary to be there for that step. And here's something easy to overlook. The notary may not also sign as a witness. So whoever is serving as your notary public cannot double up and fill the witness role at the same time. Keep those two roles separate, and make sure your witness is a different person from your notary. Follow these steps carefully, and you'll be on the right track for a valid execution. It really comes down to the principal's signature, one witness, acknowledgement before a notary, and keeping the notary and witness roles separate. Remember, this is general information, not legal or tax advice.